While the Arizona homestead exemption offers critical protection for homeowners, the law is complex and has evolved significantly through legislative amendments and court interpretations. Because homestead exemption issues often overlap with bankruptcy law, estate planning, creditor rights, and family law, determining how the statute applies in a specific situation can be difficult. Real estate professionals must recognize the importance of referring clients to the appropriate legal or financial experts when questions arise that go beyond the scope of a real estate license. Under Commissioner's Rule R4 28 1101K, a real estate licensee is required to recommend that clients seek professional advice when a transaction involves legal, tax, or other specialized matters. This rule ensures that consumers receive competent, accurate guidance, and that licensees remain compliant with Arizona's standards of professional conduct. The Arizona Department of Real Estate, ADRE, and the Real Estate Commissioner make it clear that while licensees are permitted to explain the general concepts of homestead exemption laws, they cannot interpret conflicting statutes, predict legal outcomes, or provide specific advice about how exemptions apply to individual situations. This limitation exists because homestead protection laws sometimes conflict with other legal areas, such as bankruptcy exemptions under Title 11 of the U.S. Code, federal lien enforcement, or state court interpretations involving property division in divorce. For instance, under the 2021 legislative updates, House Bill 2617, judgment creditors gain the ability to attach liens to homestead property, creating questions about when and how the protection applies. In such cases, only a licensed Arizona attorney or qualified financial professional can interpret how these changes affect a particular homeowner. A real-world example helps illustrate why professional consultation is so essential. Imagine a homeowner in Phoenix who has significant equity in their home and is facing both a credit card judgment and a pending bankruptcy filing. The homeowner asks their real estate agent whether the homestead exemption will fully protect their home equity. In this situation, the correct and ethical response is not to guess or attempt to interpret the law. Instead, the agent should advise the client to speak with a bankruptcy attorney or real estate attorney who can evaluate the homeowner's specific debts, equity, and lien positions. Providing detailed legal interpretation could be considered unauthorized practice of law, which violates both ARS Section 322153 and R428101. Similarly, during the sale of a property, an agent might encounter questions about whether judgment liens will attach to sale proceeds protected by the homestead exemption. Because Arizona law now allows judgment creditors to record liens that can attach to a homestead's excess equity, the issue can quickly become complicated. The agent's responsibility is to disclose the general existence of such laws, but to refrain from advising how those liens may or may not be enforced. The proper referral would be to a real estate attorney or title officer who is experienced in lien resolution. The Arizona State Bar maintains a referral program for consumers seeking attorneys specializing in real property and debtor-creditor matters, which can be a helpful resource for clients facing these questions. In other situations, a certified public accountant, CPA, or financial advisor may be the most appropriate referral. For instance, if a homeowner sells a protected home and is unsure about the tax implications of reinvesting proceeds within the 18-month homestead period outlined in ARS Section 33-1101, the agent should recommend that the client consult a tax professional. These professionals can help clarify whether capital gains taxes or other liabilities apply when the sale proceeds are reinvested in another residence. Real estate licensees can explain the procedural aspects of a transaction, but must avoid providing tax estimates or legal conclusions. Even courts have acknowledged the complexity and ongoing evolution of Arizona's homestead laws. In cases such as in Re. McLaughlin, Banker RD Arizona in 2022, the court addressed the tension between the newly enacted lien provisions and the existing exemption protections, noting that the law's intent to protect a homeowner's equity must be balanced with creditor rights. These rulings demonstrate why legal interpretation cannot fall within the scope of a real estate agent's responsibilities. The best practice for all licensees is to stay informed about the general principles of homestead law while maintaining professional boundaries through clear, well-documented client referrals. Review summary. Arizona's homestead exemption laws can intersect with multiple areas of law, leading to confusion and potential conflicts in interpretation. Real estate professionals must understand their duty under R4-28-1101K to recommend professional assistance whenever a client's question requires legal or financial interpretation. Attorneys, CPAs, financial advisors, and title officers are the appropriate professionals to advise clients on complex homestead matters, such as bankruptcy, liens, estate transfers, or reinvestment of proceeds. By maintaining these boundaries, licensees protect themselves from liability while ensuring their clients receive accurate and lawful guidance. Discussion. Why must real estate professionals avoid giving specific legal interpretations of homestead exemption laws? Answer. Because doing so constitutes unauthorized practice of law under ARS Section 322153 and may lead to disciplinary action. Only attorneys can interpret conflicting statutes or provide individualized legal advice. When should a licensee refer a client to an attorney instead of answering a homestead-related question directly? Answer. Whenever the client's situation involves liens, bankruptcy, estate transfers, or other legal complexities that require statutory interpretation or judgment analysis. What is the primary purpose of Commissioner's Rule R4-28-1101? Answer. To ensure that licensees refer clients to appropriate professionals when a transaction involves legal, tax, or other specialized matters beyond the agent's expertise. Closing remarks. The Arizona homestead exemption remains a vital homeowner protection, but its application often requires specialized interpretation due to overlapping laws and evolving legislation. Real estate professionals are expected to know the general framework of the law and recognize when a situation exceeds their authority. By recommending clients to qualified attorneys or financial experts, licensees uphold their fiduciary duties, avoid legal exposure, and ensure that clients make well-informed decisions. The ability to recognize when to refer a client is not just good practice, it is a hallmark of professionalism, integrity, and compliance with Arizona's real estate standards.